All right, everyone. This is March 17th, St. Patrick's Day, 2021, and we welcome you. Thank you for giving us a month off. We've been, as you may notice, starting to do these webinars 6 months a year rather than 12 months or 11. And so we're doing them every other month. We did one in January, will be March, and then next will be May, and so on. So excellent, excellent, excellent. Brilliance in Commerce, as you may know, is a project of La Vérité, which means the truth in French. And our flagship trust is the topic of today, the House of Freedom International Natural Law Trust. We are members of the Worldwide Charter for Fair International Commerce. So on the website, if you haven't already, take a look at that section. Very, very interesting. Again, today's Wednesday, March 17th, 2021, and our next webinar will be Wednesday, May 19th, 2021. Put it on your calendar and watch the newsletters, and we will give the links to that in May. For those who need a phone number, our company's phone number is 360-200-7521. It's a US number. And house-of-freedom-trust.com is the link you use if you don't already have a link from an affiliate. If you do have a link from an affiliate, we ask that you use that. My name is Tonson Fairmont. I'm the founder, and I'm a consultant in bank instruments investment programs. I've been a speaker on radio shows and former offshore investment seminars, author of a couple of books. Rendell Hillner is our guest speaker today, and he's the director of the trust department at BIC, founder of House of Freedom Trust, founder of White Light Unlimited, trustee of One People's Public Trust, and creator of the International Natural Law Trust. Our protege and assistant and all-around illustrious goddess companion and collaborator who provides some of the trust services is Dominique Hackett, present with us today. So welcome, Dominique. Thank you for joining us. Some of you know her, and some of you who are clients are attending her monthly trust study group webinars, which are for trust clients only. Today's topic is revocable versus irrevocable trusts, and proper trustee setup and laws of certainty. All right, so Randall, you are on, and I'm asking you to turn on your video and let's go.
Okay, let me see if I can go to another spot to get a better internet location. So I can speak just briefly in regards, while we're waiting for Randall, in regards to revocable trusts and irrevocable trusts. So revocable trust means that the assets that have been placed in trust by the grantor settler can be taken back out of the trust. So that's what it means by revocable. Whereas an irrevocable trust, the assets, oh, someone is saying that they can't hear. Can you hear me okay, Tonson?
Yes. Anyone
okay,
who
perfect.
cannot hear, please click on the screen and check your audio settings, because the rest of us are hearing.
Excellent, excellent. Okay, I'm a little bit closer to some Wi-Fi, so hopefully the Wi-Fi is better. Excellent, thank you, Jim. So that is the big difference between a revocable trust and an irrevocable trust. The difference is that the assets are being viewed as though they are still belonging to the grantor. And let's see. Aha,
Dominique, you may want to just turn your video off because your hand is over the camera.
Oh,
There we go.
that's funny.
There's your beautiful still photo. Okay.
Excellent. All right. So certainty of intention. Did the settler really intend to create the trust? So just briefly from some of the court cases that Randall has had me study, this is very important in recognizing that a trust exists. You have to have an express intention, whether that intention is expressed verbally or even better, the intention being expressed in writing. That is part of what is the creation of the trust, is the demonstration that the grantor really intended to place assets into a trust, whether it's revocable or irrevocable. So that's why we see trust indentures written, and in particular, the natural law trust indenture is a written contract. So in regards to certainty of intention, you need to clearly define in a schedule that there are assets that are being placed in this trust, and you write them down what the assets are. And you can start a trust with as little as a silver dollar, which is essentially starting it with like $21. So that's fine to begin a trust, but it has to name an asset. And then it also has to name the beneficiaries. So that's part of the certainty of intention, is that the grantor settler has clearly named the trustee who he's placing these assets in trust with. They clearly name the assets that are placed in trust. And if they add assets later, or the trustees add assets later, you do that with an addendum to your schedule. That's fine. And then you clearly list the beneficiaries. So those are all components recognized by law that need to be in place in order to have the existence of a trust. You have to have that certainty of intention. Randall Johnson, would you like to go to the next slide?
Okay, thank you.
So when Randall is talking to us about the family context, we're talking about, in this regard, whether it's a revocable trust or an irrevocable trust, we're looking towards future generations. So yes, we need to care for people now, but we also want to care for people further on. And that family context can be a blood relationship, or it can be our adopted family, people that are a part of our tribe. They share our same values. So equity looks for intent, not form. And was the intent clear, either verbally or written? And is the declaration in present terms or possible future gifts? And then last, is it declared or written clear enough to avoid probate? So that's what's happening. Go ahead.
Dominic, for those who don't know what is meant by equity looks for, it's referring to equity law. You want to explain that?
Yes. So the basis of when we talk about the laws that a community functions under, most of us recognize the statutory laws. Those are the laws that happen when we come together as a society, we put them in writing, and we then have an agreement that if we break that law, we're going to pay a parking ticket or we're going to pay a fine. And so with, hold on one moment. I can't go. Okay, thanks, Mom. So in regards to doing statutory law, that's something that it's a parking ticket. It's an agreement that usually the legislative branch has written and voted on, and then it becomes a body of laws. But there are laws behind that. So what gave birth to the statutory laws that we're all used to? Well, the common laws that people functioned with. An example of a common law is what's mine is mine, what's yours is yours. And if I steal from you, you have a right to ask me to give it back or make amends in some way. That just makes sense. It makes common sense of how society functions. So our common laws were those unwritten laws that existed in order for society to just work together in a way that made sense for people. And the basis of those common laws, then way back when we had kings and queens and had various rulers and so forth, they started becoming more and more, recognizable, because they went through the court, and the court meant the king's court. And the king had a chancellor. And so you could make a plea to the court. You could say, hey, normally common law says that this and this has to happen, but that's not real justice. Can you please do something different in this particular case? So there's this whole beautiful way that the laws that we are functioning with in society have evolved. And so when we talk about equity, we're really talking about what the fair and just natural process that should exist. And there are a lot of axioms of equity that are the basis of many of our statutory laws. And you'll see them written in Latin, and can't bring one to mind right now, but the idea is that you want things to be equitable and fair. That means there's equal justice for all, that people have a voice and can address any issue where harm was done, and then there's a remedy. So equity demands that there be a remedy when there's an injury. So for equity looks for intent and not form. What that gives birth to is, there's another saying, numbers don't lie, but liars can figure. The idea is that equity is that true justice of the heart that looks at, did you intend to do good, even though something didn't work out perfectly in the form, but was the intention to do good? Okay, then let's have justice follow the intention to do good. If you intended ill, even though the form may be perfect, we should follow the intention, and you should be held accountable for the ill that you have done. So equity looks for intent and not form. So when we create a trust, whether it's a more statutory revocable living trust or the private contract that Brilliance and Commerce, Townsend and Randall is the creator of, the private irrevocable trust, that is a contract. Both of those are clearly stating an intention. And so when we talk about trust, the intention is looked at in four simple things. Whether you have a grantor who has made an arrangement with trustees to put assets into their trust for the benefit of beneficiaries. So the form of any particular trust can be written in different ways and still hold the intent of being a trust. And part of why the Brilliance and Commerce Trust is the private irrevocable contract is so beautiful. Randall has worked many, many years to put this trust indenture in English rather than filling it with legalese. So it is a clear document that can be read and understood by the common person. You don't need a legal education to understand how to run your trust. So was the intent clear, either verbally or written? That's very important for revocable trust and irrevocable. We always recommend that you put things in writing. When you view a trust, you really view it kind of like a business, in the sense that what makes good business sense? You would want to put a contract in writing. So if you put a contract in writing, then you would want to put your trust in writing as well. And with the idea that the declaration is in present terms or possible future gifts, that has to do with the powers that the grantor is giving to the trustees. In other words, the grantor is clearly declaring that the trust that they're placing in their trustees is that the trustees will care for the assets in present terms. You're caring for them right now, and you're caring for the beneficiaries. And in the private irrevocable trust, we also call Brilliance and Commerce's trust a discretionary trust, because the trustees have the discretion of possible future gifts. They have the discretion of how best to care for beneficiaries. And this is beautifully written in the declaration. The declaration is the trust indenture. And a trust indenture, whether it is a statutory revocable trust or whether it is a private irrevocable contract, it's still considered a declaration because it is declaring the intent of the settlor and grantor. So is it declared or written clear enough to avoid probate? So this is usually the reason why people start looking at trusts, whether a revocable trust or a private irrevocable trust contract. It is in order to avoid the probate courts, which is when a person becomes deceased, there is no one set up to care for the assets unless the person has taken the time to create a document that clearly details their intentions. So most of us are familiar with wills, my last will and testament of John Smith. And then it clearly states what the intentions of John Smith are. And why do we need things like wills and trusts? It's because when you're no longer here, the courts recognize that those assets need to be owned by someone. And so they're looking for directions. And if you have left no directions, either a will or a will and a trust, then the courts go through a process. And in the United States, each state has a set of laws, they call them probate laws, where they determine who the heir is. And in California, it takes about 2 years because the courts are so behind, and the courts will take their fee and they will literally create a trust for you, set up a trustee, and then all your assets are gathered, and then the court determines who's going to receive what. And it's a very sad situation when people unfortunately leave and have not addressed what's happening with their assets. So in looking at what you can do, number one, people do look at writing a will. That's great. But the best way to stay out of being thrown into a probate court is if you have a trust. And, excuse me. And if you talk to your neighbors, most of the people around you are familiar with a revocable living trust. And that's most common simply because the statutory lawyers and so forth in the various courts of, in particular, the United States, they enjoy working with revocable living trusts. And then you have Brilliance and Commerce, who is presenting you with a private irrevocable trust contract. So first I'll address the revocable living trust. So that is a document. Just about every state in the United States has a pretty standardized form that people follow that makes sure to clearly address the intentions of the settlor and grantor to put particular assets. And it's usually your house. There are other things you can do with bank accounts and investment accounts, but it's usually a residence that's placed into a revocable living trust. And then it will say things like, what happens if I'm incapacitated? So I haven't deceased, I haven't passed away, but I'm incapacitated. And so this revocable living trust document can address caring for you while you're incapacitated. Then it also, and that's the living part of it. And then when you do become deceased, your revocable living trust suddenly becomes irrevocable. And why does that happen? Because you as the grantor are the only person who could have revoked your decision to put your house in your trust. You're the only one. So if you're no longer there, the trust is now viewed as being irrevocable. Now, the irrevocable trust that occurs from a revocable living trust is different from Brilliance and Commerce's natural law trust, which is a private irrevocable contract. And the difference, the main difference, has to do with how the beneficiaries are cared for and the powers of the trustees. And the intention behind a private irrevocable trust is that this trust will be renewed like around every 20 years or so. The trustees get together and say, hey, are we having a good time with this, caring for the assets and caring for the beneficiaries? And shall we continue? Because you can't have a contract go on in perpetuity. So you have to renew the intention to keep a trust going. But that is the intention behind the private irrevocable trust, is that this is a gift to the family now, as well as to future generations. With the revocable living trust, which is more of a statutory setup, when it becomes irrevocable, it usually exists for only about 2 years. And its purpose is to keep you out of probate. So there is a very specific trust certification form that you would fill out, and you literally file that with the court. You'd file it in the assessor's office. And what it's telling the assessor is, hey, I've got it under control. We have a trust. We don't need to go in front of a judge because John Smith clearly left his intentions of what he wants to happen if he's no longer here. And he's no longer here now. Here's the trust certification. I'm the new trustee per his document, and I'm going to handle what's happening with the assets and taking care of the beneficiaries. So that's a beautiful thing. You stay out of probate. And that more statutory, irrevocable trust is going to get closed out in about 2 years. It takes about 2 years to wrap up, gathering up all the assets, figuring out based upon what's in writing, who gets what, divvying that out, paying any final taxes, and then closing the trust. And that's what happens on the revocable living trust side of the equation. On the other hand, with a private irrevocable trust, when the original person, your grantor, passes away, nothing changes. The trustees continue to do their job. They continue to care for the assets and care for the beneficiaries. And what the beautiful thing is, now the family can come together and they can grieve and they can honor the life of the person who has passed. But there's no stress of paperwork. There's no stress of divvying up assets. Usually we ask people to, they call it a pour over will. So you always have, like maybe you collect baseball cards, or maybe you collect beautiful crystals, and you want the things that were precious to you to be passed on to someone. So having a pour over will ensures that those items can be given to who you want them to go to, but that we're not talking about a huge asset that someone would then, want to tax or charge a fee on. So it's a much gentler process, honoring when the grantor, in my opinion, when the grantor passes, if you have a natural law trust. So the idea of avoiding probate is usually what makes people take on the education of looking at whether they want to do a revocable living trust or whether they want to get into doing a private irrevocable trust contract. Hope I haven't talked too much on that one slide.
No, it's fine. Thank you. That's eloquent and clear and beautiful. And just for those who are new, of course, you may know that questions are entertained later in the program. So type them into chat, or if you're on by phone, you can raise your hand by pressing *9 later on when we open it up to Q&A, but you can be writing down your questions for now. Dominique, I don't see any sign of Randall yet. He hasn't responded. So thank you so much for carrying this.
Absolutely. And I know that now he had a lot of rains and he had a lot of internet issues. So we may simply be in an internet out period for him.
Yeah. Well, I see him on the list of participants, which is strange. And I've approved his video and audio to be on, but it's not visible.
Ah, darn. He
I've
may
sent
have a
text by phone, and had no response to the phone text.
okay.
And also a private chat message. So
I'm sure he's trying to figure it out.
yeah. So anyway, you are saving the day. Thank you so much.
Oh, someone says that they can see Randall. Hang on one sec. Yes, I can see Randall too. Can you see Randall Townsend?
No, but maybe my as a host, my screen may be different.
Okay. Randall, let's see if I can just for a moment. Let's see. Townsend, if you make me a co-trustee, co-host, sorry.
I'll make a co-trustee, yes.
Let me see if I can help with pulling Randall in, because he is there.
All right, you are now co-host.
Oh, you know what I think happened? Okay, Randall, if you can hear me, I think what happened is instead of clicking using the computer internet, you clicked audio. So if you click out of the Zoom and then come back in and click the very first one that says you want to use the internet, that should give you sound. Darn, I can see Randall's talking. We may also have a time lag too. Townsend, do you have the ability to ring Randall on the telephone?
Yeah.
Because he may not be able, he may be talking and not hearing what we're saying. Yeah, we may have a comedy going on. So do you want to try to ring him on your cell phone?
Yes. So please carry on.
Very good. Will do. Okay. So we have, did the settlor declare a trust or power of appointment? So this has to do with how the trust indenture is set up, whether it is a revocable trust or a living trust. Both of these documents have to clearly say John Smith is the grantor, and for those who are new, grantor and settlor are interchangeable terms. So did the settlor declare a trust or power of appointment? That occurs in both trust indentures, where you clearly say, I'm the grantor, I'm the settlor, and Jane Doe is my trustee. So it's written very clearly. And some documents will even say, Jane Doe is my trustee and Don Hackett is my successor trustee. So you can even name the trustee and you can name a successor trustee. Let's see. So we want to have an intention that is clear. And if we're not clear and we're just stating a wish, and I can give you an example of this, there can be an issue with that. So here's my example. In a revocable living trust that I know of a friend, when she passed away, she had a wish that a nonprofit would be started after she had passed away. And she had books that she was donating to the nonprofit. The problem with her trust was she did not leave any directions of who would begin the nonprofit and who agreed to it, and how it would be funded. So even though she expressed a wish that a nonprofit would be formed and that she had these books to give to the nonprofit, the lawyers involved with how to handle, so it didn't go to a court, but there were lawyers involved in how to handle her trust after she had passed away. They decided that it was the expression of a wish, and it did not have a clear intention of how to fulfill the wish. So they decided that it couldn't be fulfilled. And there are actually some legal terms in regards to that, where if a trust is expressed but it's not, you don't have all the pieces set up there, so it's not perfectly done, the courts cannot do it for you. So you have to, and that's why we work with Randall, you have to properly declare what you want done and not leave it as what I wish would happen. Because what you wish would happen may not happen after you're no longer here. And let's see, I'm going to check the chat room just a moment. Darn. So technical difficulties, we'll keep on going. So did settler really create a trust? That's the whole question. Is there really a trust there? And the four basic components are clearly define who the grantor is, clearly define that there is a trustee. And when part of the trust document is that this trustee has accepted the appointment. And interestingly, in a private revocable trust, that appointment page is there. And it's very clear that the trustee has accepted being a trustee. With a statutory revocable trust, the grantor remains the trustee, and he names someone who he wishes to be his successor trustee when he's no longer there. But guess what? When he is deceased, being a trustee is an at-will contract. In other words, if I'm going to be a trustee, I decide that I'm going to do it. And if I decide I'm not going to do it, then I say, no, I can't take that on. I'm not going to be trustee. So it's at my will that I become a trustee. And this is the case for a revocable trust or a private irrevocable contract. It's an at-will agreement. So with a revocable trust, even though the grantor has named his successor trustee, the person who should take over when he's no longer here, there's no appointment page. So you don't know whether that person has really agreed to do it or not. And after you're no longer here, so usually you appoint at least two options if you have a revocable trust, because you may talk to them and they may say, yeah, but you don't know actually if they're really going to do it. Whereas when you're working with the Brilliance and Commerce Natural Law Trust, the grantor starts working with the trustees and they set in motion, and he gets to see that they know what they're doing, that they're getting an education, and that they are taking on the role of caring for those assets for the benefit of the beneficiaries. So did the settler really create a trust? That will be found inside of the trust declaration, the trust contract. Or only a way to deceive creditors. So that's always the suspicion when someone hears, oh, well, so-and-so doesn't have any assets anymore. They have put them in a trust. That question is very, very important and should be taken very seriously, because everything that we do in regards to placing assets in a trust, we do it from a standpoint of we want to honor the legality of things. So if you have an issue with an asset, say, take something simple. you have a house with a mortgage and you want to put your house into your trust. Well, you understand the mortgage will follow the asset because that makes sense. That's equitable. That's just. So if a creditor is coming after you for something, the courts have maintained, in not only the United States, but in England and in multiple countries, there is a certain amount of time where if a creditor presses on you, they could get the courts to reverse the transaction if you put all of the assets into a trust and you knew that there was a creditor who was owed monies. They deem that as suspicious. So we do want to, or when people study, should I own something or should I put it in a trust? Many of us, when we study this, we realize our assets are better protected if we do not personally own them. So when we personally do not own them, we're talking about further on down the line, like even 2 years down the line, then you become clear and never can a creditor come after your assets because you don't have the asset. It is clearly owned by the trust. So if you have questions about an asset that you want to put into your natural law trust, and you think there might be a creditor coming after you, send an email to Randall and have a conversation with him on it. And he can help you to make sure that you are never perceived as trying to deceive a creditor, because that's not a good thing. But we do recognize that it is healthy to put our assets into trust so that in the future, that's never a possibility, because we have a well-functioning trust and we don't own any assets. So I think, did I catch everything on that slide? Yes, that looks good. And I apologize, Tonson, I'm not able to look at the slides and the chat, so I haven't caught up with the chats. I'm on my telefono.
Randall just says it is currently 1340 on Kauai, a beautiful sunny day.
Uh-oh. I think this is a comedy.
All right. Thank you so much for carrying this, Dominique. You're doing a beautiful job. Let me let you continue while I try to still get some word to Randall.
Okay, well, maybe send him a text and say if he can call you on a particular cell phone.
Yep.
Perfect.
Next
Can
slide.
you flip? Yes, can you flip to the next slide? Thank you so much. And everyone, thank you so much for your patience. And I'm so hopeful that we'll get Randall on because his wealth of knowledge far exceeds my humble attempts of enjoying this subject with you today. So, certainty of subject, matter, and objects. And then we have common issues, conceptual uncertainty, and vagueness of language. So I'll just speak to you a little bit about these concepts. My background is construction, actually. I owned 2 construction companies for, basically 15 years, and I was in construction another 15 years. So for about 30 years, I've had the pleasure of reading construction contracts, and I can speak to the necessity of the subject matter and the objects, how important it is to use language to be clear rather than using language that is deceiving. And part of the frustration, when you think about taking your assets and putting them into a trust, whether you're thinking of a revocable trust or Brilliance and Commerce's natural law trust, there are so many things that we don't know about the future, that there is, or at least for myself, there is this desire to be vague so that I can keep my options open, right? But that's actually not an asset. The asset is in clearly defining what the powers of the trustees are and clearly defining the intention of the grantor by clearly setting up who the beneficiaries are and clearly setting up who the assets are. And this is the way that we create the flexibility in the future. So in your revocable living trust, the powers of the trustees are very limited. They take over the ownership of the asset for the benefit of the trust, and their purpose is to divvy up the assets to the beneficiaries, however it is spelled out in the trust indenture. And honoring, there may be some final comments from a will, so you have to take that into consideration. But for the most part, it'll be clearly set out in that trust indenture, and then that's it. Those are the limited powers of the trustee. It's close it out, doesn't exist anymore, file the final tax return, and sayonara, it's end. With the private irrevocable contract, it is so different. The powers of the trustees are very well written out by Randall, and they include, let's see, hang on one second. Let me see if I can read the last chat. Oh, good. He's going to try to figure out how to get on. Okay. So the way that Randall has written the trust indenture and delineated the powers of the trustees, it includes things like giving the trustees an ability to give a gift, because maybe me as the grantor, I have a favorite nonprofit. And if the assets are doing great and my beneficiaries are well cared for, I would like the trustees to care for a nonprofit that I was really fond of. So that's written in the powers of the trustees. The trustees are able to take in additional assets to grow the trust, because this helps to care for the beneficiaries. And they have the power to, if the beneficiaries say, you know, I don't really need to be cared for, but I would like my children to be cared for. The trustees have the ability to take back what is called a certificate, that is a beneficial interest certificate, and reissue it to your children. So there are some very beautiful trustee powers that give that flexibility. So if you have that sensation of, oh, I don't know if I want to put my assets in a trust because the future is unknown, I'm trying to tell you, list out for yourself some of your concerns about why you think you should stay vague, and then address those concerns with Randall, and he will help you understand that the trust indenture has flexibility built into it by the powers that have been given to the trustees. And with the vagueness of language, if we strive in all of our relationships to use language clearly, our relationships go so much better. And instead of assuming, and we all know when you spell the word assume, it's to make an ass out of you and me. So instead of assuming, we should really do a check-in and ask questions. And that's using language very clearly and double checking on intentions. So when you work with Randall and you get a natural law trust, private irrevocable contract, you have the opportunity to read and ask Randall questions before you finish signing the documents, so that you know you understand your document and you understand how your trust works. And he also gives a trust manual so that you can help understand. It's like being given this really great car, and now you get to figure out how to drive it. And then I'm helping once a month. We are getting together and talking about going through different books and talking about different subjects and trying to address anyone's current issues that they may be handling. It's usually paperwork, so trust administration. And we have a lot of fun going from 1 month to the next, staying together and studying together. So I think that's it for that slide. Tunson, are you there? And Tunson may be trying to get Randall on. Hello.
Well, Randall is not responding to, we're not getting any audio or video. And
Oh, shoot.
and when I click on ask to unmute, it doesn't respond. It's the button is unresponsive.
Okay, so we've got a Zoom glitch.
Yeah.
My mentor is going to laugh at my presentation of his seminar.
I don't think so. I think you're going to get a lot of praise.
Oh, I just want to say one thing. Working with Randall is such a joy. He's really easy to email questions to, and his wealth of knowledge and experience is just, I mean, 30 plus years. It's really, really deeply appreciated. So he might have appeared again. I know he's trying so hard to get in there. After this seminar at Tunson, we could do a separate little Zoom and try to figure out which of the settings aren't set right on his computer. And I didn't think of running that with him. Poor fellow.
Right.
All right. So evidential uncertainty: can evidence be found to support the intention? And then whereabouts uncertainty can the beneficiary be found? So this is the importance of clearly defining who the beneficiaries are. And the evidence of the beneficiaries is usually found as a schedule attached to a trust, or if you have a revocable living trust, it's written inside of the trust indenture. And the evidence is, I mean, when you're not here anymore, the evidence is what you've written in your document. And I have to tell you, if you put a Post-it on your document and say, you know, add Noah Jones, that's not good enough. And also, if you write on your trust document, that's not good either. So whenever you execute a contract, you want to be very careful whether it is a revocable living trust or whether it is a private irrevocable contract. Once you issue a document, you don't write on it. That's what creates the uncertainty. There we go. And what helps to clear the vagueness is your trust minutes. And unfortunately, I've seen a lot of living revocable trusts that then the person has passed away and it turns irrevocable. And then the trustee is working with that trust and working with the heirs, and there's no minutes. There's no documentation of why they did this or why they did that, because that's not usually taught as necessary in trust administration. But when you work with brilliance and commerce and you work with a natural law trust, you are given instructions in the trust manual of how to do trust minutes. And basically, it's very similar to corporate minutes or the minutes for an LLC. You want to clearly state how the grantor's intentions are being fulfilled by the trustees. And that's part of what keeps uncertainty out of the equation. And in regards to your beneficiaries, the uncertainty, the way you keep that out of the equation is having it clearly written down. And so when you work with Randall, he's really good about helping you work out who should be a beneficiary and perhaps someone who maybe shouldn't be a beneficiary. There are reasons why we would make some of our family members beneficiaries and maybe others not. And so it's really nice to work with Randall and have those private conversations. Oh dear. Zoom is really funny. Can you still hear me, Tanzan?
Oh, yeah, I was muted. Oh, yes, yes, absolutely.
Well, so I have Zoom on my phone. Just to let the audience know, if you touch your screen, all of a sudden it flips and it thinks that you're driving. And now it wants you to tap the screen if you want to talk. So there's a whole comedy of stuff that happened with Zoom.
Yeah.
So would you like to go to the next slide?
Yes.
Excellent. So we have certainty of subject matter and objects. We're looking at particular issues, identifiable beneficiaries, and identifiable property. So this is part of why it is that working with the private irrevocable contract is so nice. Hang on, I have someone coming through on my phone. So when we work with Randall and the private irrevocable contract, the beneficiaries are clearly identified and the property is clearly identified. Frequently in a revocable living trust, there will be a huge paragraph that will generally declare what a person has, and you just put this big paragraph that includes precious metals, jewelry, pictures. You just you name everything as best you can and you throw it into a paragraph. Whereas when you work with Randall in your private irrevocable contract, what you do with your assets is, if you have a collection, say you have a collection of baseball cards, you would take a picture and you'd put that in the binder and you'd properly list it in your schedule. Say you have a collection of coins, you can take a picture of those coins and you put it in the binder and you properly declare what it is. You're very careful about identifying the property that is in the trust, as well as identifying your beneficiaries. So I have opportunities where I work with revocable trusts as well as our natural law trust. And I've seen a lot of revocable trusts written by, really well-known lawyers, and their trust declaration is not as clean and clear as Randall's private irrevocable contract. So really happy with that. Particular issues. So some of the issues that come up are, say you've put some assets in the trust, and then as you live your life and you're happy with how the trustees are handling things, maybe you decide to put other assets in. And then the question is, do you put those in the same trust, or do you perhaps form a new trust? So it'll be fun to see when in the questions and answers, people will they'll offer different situations they have that have to do with their beneficiaries and their properties. So, but the certainty of the subject matter and the objects, that expressing yourself in writing and clearly will solve the vagueness of those problems. Tanzan, would you like to go to the next slide? And by the way, these slides are gorgeous to look at. Thank you so much. So effects of uncertainty. We have, if above criteria are not met, trust fails. And that's why the natural law trust rules. So with the example that I gave of my one friend who passed away and her wish for forming a nonprofit, that was not, that wish could not be executed because she did not leave the funding for it to happen. So the worst thing that happens when you have uncertainty, the worst thing is ending up in court and then having a judge decide what your intention was and decide based on documents what he thinks should happen with who he can determine are the beneficiaries and who he can determine or what he can determine are the assets. So that's worst case scenario basically is you end up in probate court and you get charged fees and many different things now become out of your control. And the beautiful thing about the natural law trust is the grantor is alive and he gets to see that the trustees clearly understand how to care for the assets and how to care for the beneficiaries. So it's this beautiful unfolding of the trust relationship in that safe space of the natural law trust with a clearly written trust indenture that's in English. And you can very clearly understand what your powers are. So the effects of uncertainty is either the trust is broken, in other words, it's not recognized as a trust, so then your assets are treated as though they were still owned by John Smith and the trust never existed. And then if John Smith is not here anymore, it ends up in probate. So yes, the natural law of trust rules. It rules for so many reasons, but the clearly written trust indenture is just a beautiful gift. Next slide.
Okay,
Questions?
everyone. Thank you, Dominique. So everyone, if you have questions, press *9 if you're on the phone. If you're on the computer, type it into chat or click on the raise hand icon, and then we'll put you on to speak.
And don't be shy. Questions are welcomed. Even if you feel like the question may have been asked before, all questions lead to unfolding knowledge is my experience.
I will say that while we're waiting for questions to come in, there's been a lot of other speakers out there from other companies talking about that revocable trusts are more recommended and that they're steering people away from irrevocable trusts, saying they're too rigid or too risky or whatever because they misunderstand them or because other organizations do not have the flexibility in what the roles are that the client can play, such as the client with the natural law trust can play grantor, beneficiary, and manager or trustee. And in other words, the client can stay in control of his or her assets if he or she wishes, as you know. And so can you elaborate on what the revocable trust risks are to someone's assets and why we don't recommend it?
Sure. So the main thing that people have to understand is we call it wearing different hats. So you have the grantor hat, that's the person who puts the assets into a trust. You have the trustee hat, that's the person who's now caring for those assets and holds the legal title in the name of the trust and is also caring for the beneficiaries. And then you have the hat of the beneficiary. So our main hats are grantor, trustee, beneficiary. So in the revocable living trust, one person is all three hats. That one person is the grantor, John Smith. John Smith is also the trustee until he dies. And John Smith is also the beneficiary until he dies.
One of them.
One of them. And he can name other beneficiaries as well. So in that case, the assets never leave his control. They never leave him. So he does not have any asset protection because he still personally owns the asset. So what do we mean by asset protection? That means that if John Smith gets into a car accident, heaven forbid, and is personally sued, everything he owns could be on the line, his residence, his bank account, his investments. Whereas if John Smith was working with a private irrevocable contract and had put his residence into the trust, and the trust was functioning for a little bit of time, there has to be a little bit of distance, then his asset is now protected. And if he is sued from a car accident, they don't recognize him as owning that house because it's clearly owned by a trust. So now he has clear asset protection. So asset protection involves, one, how the trust is set up, and then two, how transactions are done. So that's the main thing about a revocable living trust. It's no different than you. That's why it says revocable. You can take it back. So therefore, you never really gave it away. So it's always you. It's still you. Whereas with the private irrevocable contract of the National Law Trust, it's no longer you. You put your house into a trust, you do the quick deed, change on the quick deed to the name of the trust. And the only thing that would follow that would be a mortgage or something that was, if the property was encumbered in some way. So that's the beautiful nature of a private irrevocable contract. And people should understand, who is the speaker who is telling you to do a revocable living trust? Is it a lawyer? And I'm just asking because most lawyers, just like doctors are not taught about nutrition, they get maybe 4 classes in nutrition or 4 hours. It's something very small. Lawyers are not coached on private irrevocable contracts. So what they're coached on is statutory law, and statutory law favors the revocable living trust that turns irrevocable after you die and then disappears, because they've put a lot of statutory laws around it. So that one is a moving object that they are really familiar with. And so that's the one they try to sell people.
Okay, we have some people who've raised their hands, and Silver Feather, I would like to unmute you and ask you to click on your unmute. There you are.
Yeah, thank you, sir. Okay. Very kind gentleman opening the car door for me. I'm in transit. Yes, my question is, I have your trust, but I haven't filled out any paperwork because my situation is very complicated. I was hoping I would get clarity. But my question is right now is, I just learned from you tonight, I didn't know this, that the revocable trust that I had with parents, I was an only child, my parents' property and some which I sold is no longer, I was just about to go contact the attorney because my copy is in storage in another state. I was about to contact the attorney to see if I could use that for currency exchange. And so my question, I have 2 questions. One is, does the living revocable trust have an EIN number?
So, hi. So usually with a revocable living trust, when the, if it's a marital revocable living trust, that living trust usually separates into 2 trusts after one of the spouses passes away. And I don't know what the trust indenture says. So I'm going to share you some thoughts, but you won't actually know until you actually read your trust indenture. Does that make sense?
Yeah, well, both of my parents passed away. I was the only trustee with them.
Got it. So when they both passed away, that trust has now changed to a irrevocable trust. And at that point, normally, if you have a CPA working with you or someone filing for your family estate, they would have obtained an EIN number for that irrevocable trust. That irrevocable trust, if you have the natural law trust, you can compare the two documents and you can see the differences of how they function.
Right, I understand that now, but my question again is, I'm getting mixed signals about whether when you exchange foreign currency into the new quantum financial system, you need EIN number to open a bank account. So that's, you know.
Yeah, so we're talking about a couple of different things. Unfortunately, in this seminar, usually we only focus on questions regarding trust, because I don't have any firsthand knowledge about what we're all hoping is going to happen sooner rather than later.
Right. Okay.
So we're all trying to figure our way through that. The reason for an EIN number is because of the Patriot Act and what has been enacted in many different countries, where they're trying to be more careful about money laundering, and they're trying to watch for human trafficking and drug trafficking and so forth. So in the United States, that's the requirement for an EIN number, is so that if a person doesn't have a social security number that we're able to track their money trail, then we want an entity to have an EIN number. And obtaining that EIN number is actually very easy. The IRS has made it very easy to go online and to get one. And it even says for banking purposes. So you would have to, for your particular situation, you would have to look and see if the person in charge of the assets, if they went and got an EIN number. If they did not go to get one, then no, you don't have one. It doesn't get automatically assigned by anyone. So it's something that has to be obtained. So the same process of obtaining an EIN for a revocable living trust that turns irrevocable when the people have died, that same process is the same process that the natural law trust goes through to obtain an EIN number for banking purposes. So the question, yeah. So the question about whether to put foreign currency as an asset, so you can look at that as a collectible. So whether it's baseball cards or whether we're talking about foreign currency, we're talking about an asset that we hope will appreciate at some point. And at that point of appreciating, we're hoping that we can do other things with it. So then your question would be, do you enjoy working with the indenture that is left to you from the trust contract that your parents created? Or do you like working with the trust indenture that is created, that Randall created as the natural law trust? And that
no, I've been planning all along to do the natural law trust. I was just, it's just a transitional situation that I'm dealing with. But the question then would be, can I use the natural, the banks would not, they would not be able to deal with the natural, with my natural law trust, right? They don't deal with them.
I have a bank account at our local community bank. No, I had no problem. So in regards to banking, you work with Randall on this. And what I do is I just went to my local community bank and I said, do you have trusts as clients? And the person who I spoke to said, yes. And I said, okay, great. I want to open up an account. And so I brought my, initial trust indenture with me, and I brought, I had another trustee. So both trustees went in, and they had us fill out their trust indenture, trust certification document, which is no problem. I marked irrevocable, and I marked all the powers that I have, and I had no problem opening a trust bank account.
Dominique, it's important to add to
this
that.
This would be a tier 1 bank, though. This would be a tier 1 bank. So I don't. That's different.
It's important to follow the instructions in the trust itself about how to open the bank account.
Okay, could I put my foreign currency in your trust?
Yes, that form comes with it. You must not have read it. That form.
I haven't gotten any paperwork yet.
Oh, I thought you
because of
said
the
you had it.
No, I purchased it, but I haven't done any paperwork just because I don't have a trustee. So,
I see.
you know,
Gotcha,
so that's
gotcha.
yeah. I mean,
Okay.
I have a friend, but I mean, I don't see her as a permanent, but I can't, I have to make a decision and stay with it. Is that correct?
So it sounds like you have some really good questions that you're probably corresponding with Randall on through the email.
Yes.
That's
what
excellent.
Yes,
that's what I need to do.
Yeah.
This forum is for questions that everyone would benefit from hearing.
Right. Got it. Okay. Sorry. Yeah, I get it.
That was a good question. That was an excellent question on whether you can put foreign currency into a trust.
That's
so right
included.
now,
that form is
Okay.
included with the trust for the.
Oh, wonderful. That's what I need.
Yes.
That's very helpful information. Thank you very much. Okay. Thank you so much.
Absolutely.
Bye now.
Thank you for your questions.
Thank you.
Thank you.
Okay, next we have Christopher. I'm asking you to unmute so you can be on the air. Go ahead.
Hello.
Christopher, hi.
Thanks so much for putting on this webinar. I'm learning a lot. We have a little bit of experience not using a trust, but we've just, learned a bit about trusts. And now we're finally ready to kind of take our plunge into our first trust. And we definitely like the idea of working with Randall. And my intention here is to start one business and maybe end up starting 2 or 3 businesses with the trust. And I'm just wondering, how do you run a business utilizing the trust entity?
Excellent question. So whether it's a, it's going to sound strange, whether it's a revocable living trust or it's a private irrevocable trust, it's kind of the same idea that you're going to write down. So if you have a corporation, you have owners of your shares of your corporation, correct? If you have a C Corp. So with a C Corp, you would give some shares to your trust. And that's how the trust participates in the ownership of a C Corp. It's similar with an S Corp. You still have shares of a corporation and you're issuing shares. With an LLC, you have members. And so the LLC in their articles of organization, they would list the trust as a member of their LLC. And then with partnerships, you could list the trust as a partner, as part of a partnership. And I'm trying to think of any other, I mean, there's also
so we're looking at running maybe an S Corp.
An S Corp. Okay. So an S Corp is a statutory entity. So with a statutory entity, because when you form an S Corp, you form it in a state and a state recognizes you. So that becomes a statutory business. So you'll be filing the S Corp tax returns. And normally an S Corp is passive. So it will, any income that comes from your S Corp would show up to you as an individual. Does that make sense?
Right. So the trust wouldn't be able to be that individual then?
Well, technically it could. And then you can work out how the distribution to, what I like to tell people is, your trust should be treated as a pass-through entity. So handle any taxing issues before the monies go in, or know that the beneficiaries may have to handle taxing issues after it comes out. And there is some really nice complexities in a private irrevocable trust in regards to whether you are distributing income or whether you're distributing corpus to your beneficiaries. So there's some additional flexibility there in regards to the private irrevocable trust. But yes, the trust does and can participate as an owner or a partner or a member of a business.
Okay,
And-
I don't have my heart set on an S Corp. I just kind of threw that out there. I'm open to learning what would be the best way to do that.
Yeah, and it usually has to do with what your business is. Is your business a service? Is it construction? Are you licensed to do something?
Yeah, right now I'm licensed to sell insurance, but we also want to do some, marketing of products online, things like that.
Right. Okay. So as an insurance agent and you're a licensed person, usually I think the best setup for that is an LLC. You have to research it yourself. But I used to be an insurance agent here in California, and I have my girlfriend's an insurance agent. She has an LLC. So, and the reason for that is you hold a license. And so that license, what do you call, it's similar to doctors. It's anyone who's in a licensed capacity. They usually are either a sole proprietorship, or they are an LLC, limited liability company, or they're a partnership. That's normally what's done for people with licenses. And then the second thing is with other products that you want to suggest and share, you may want to set that up as, especially if you share it multiple states, if you're in the United States, you may want to look into a Wyoming LLC, because Wyoming doesn't have any state income tax. Just some thoughts for you.
Well, I'm in Florida, and fortunately, we don't have any state income tax either.
Nice. Yeah. So that's kind of the complexity of your business, of how you set things up. You can do things as makes sense to you, and then as the funds flow into your trust, you get to decide, does it flow in because it's a member of an LLC or an owner of shares, or is it a contribution that the trustees are gathering in and exchanging for units of beneficial interest? So I would write an email to Randall of what your particular situation is, and he can give you some excellent suggestions.
Okay, great. I was wondering if it's possible to just run a business with the trust as the entity instead of having like a corporation or something like that as the entity.
Yes, and Tanzan and Randall both can speak to that. Do you want to say some things, Tanzan?
That's how Brilliance in Commerce is operated. I've never had any need for a statutory entity.
Well, that sounds good to me. Let's definitely talk about this and see what we can do.
Yeah, most people only use an entity if they already have the business in a corporation or LLC, and they're used to it. They're accustomed to it. Their bookkeeping is already in it, and they want to keep it going that way because they're on a track already. So then they just add the trust to sit in the background and hold most of the assets of that entity. But for those who just have a natural law trust and you want to start a business or add a business into it, you can title the title of ownership of the business into the trust and operate the business directly from the trust.
That's looking very attractive.
Yeah.
Excellent.
Okay.
So that pretty much answers my question for today. I'm just probably going to be wanting to look at the next steps in moving forward with y'all.
Thank you, Christopher. Okay, so we have Oscar. Oscar, you are with your hand up, and we're going to unmute you. So please go ahead.
Well, very much thank you to Dominique for doing such a superb job today and flying improvised style, which was remarkable, but you handled it perfectly. So congratulations.
That's very kind.
Yeah. And to Tanzan, I want to say thank you for hosting this. It really is extremely helpful, and it's definitely cleared up some cobwebs. Also, I love your affluence, opulence, and heaven on earth consciousness that you keep posting with all your beautiful imagery. So it really helps to have that state of consciousness as we're watching this, because what I have come to appreciate and understand about BIC, Brilliance in Commerce, after being a side observer for almost a year. I wasn't ready to do the trust until now, but the point I'm making is that I really appreciate the level of consciousness that's embodied in this group and in this service that you're providing.
Thank you so much. And it's mutual. We really, really appreciate you and everyone who's been joining us. And we've been very fortunate to attract many of the cream of mankind.
Beautiful. Well, it makes sense. Like attracts like. I also concur with Christopher, who was just on, about the corporations. It's been something always in the back of my mind. I am already setting up a trust now for the RV. And so that is a separate steward package in itself for humanitarian projects. But what I'm really focused on as well, once that's established, what I really want to focus on is I have 2 S corporations. One is a dance school, and the other one is a little bit challenging to explain it, but it's about raising the consciousness of humanity on the planet to provide consciousness to heal the planet. And so I guess I would call that a service business or an educational business. And both of these entities are S Corps, and I want to get out of the corporation aspect of things and morph into the BIC consciousness format. And I'd love to get help with that as much as possible.
That, evolving businesses and shifting, it's very, very interesting, especially coming from a more statutory into a more private contract. It's a real gentle process. And what I would do is I would map out for yourself of where you're currently at and then where you want to go. And just know that a private irrevocable trust can hold multiple bank accounts. So in other words, just like you as a person, you can have multiple checking accounts. Same with your trust, can have multiple checking accounts. And that may be a way that you keep the bookkeeping separate for your different endeavors, if that's important to you. But other than that, yeah, it's just a matter of shifting out of the statutory world into the world of a private contract.
Because once we shift into the private contract, then we no longer have to fuss with IRS or any of that stuff. Is that correct?
Well, what I explain to people, it depends on what your current situation is. But normally we function with, I teach people to do accounting for your trust as a pass-through entity. So if there's any taxing situation that occurs, you try to handle that before the funds come into the trust. And then when a beneficiary receives benefit, they may have a taxing issue at that end on the receiving side. So the specific taxing questions, put them in an email to Randall and get his comments on them.
Okay, that sounds good. I mean, this will be a step-by-step process, and as I get stronger in my understanding of how the trusts operate and how they function, I'll be building other trusts just to exercise like the vehicles and the home and etc. and kind of groom myself into understanding how these all work until finally we'll mature into what you're talking about.
Yeah, and just know that, I mean, for the larger, wealthier families in the United States and around the world, they have been using private irrevocable contract trusts for centuries, and that's how their wealth has been passed on. And they use different trusts for different assets. And in particular, the vehicles is a tricky one because unfortunately our vehicles are also a possible liability. So just put in your thoughts, you never mix a vehicle with a house. Does that make sense?
Yes. Yes. Hold on.
Beautiful.
Okay.
Love where you're going.
Thank you. I appreciate your support and your help and your service. Thank you.
Thank you for your
Absolutely.
high consciousness as well, Oscar. Okay, so we have had some questions in chat, Dominique. One of them says, hi, Dominique, and this is from Oscar, but maybe it's already answered. I have 2 S Corps. Do I need to change to a trust format? So hopefully, Oscar, that was addressed. And then Christy asks about transferring home into trust even while it has an equity loan on it.
So, and situations like that, what you would do is you'd literally call up your mortgage company and you tell them, hey, I'm in the process of creating, and you just say a family trust. You don't have to give them a whole lot of details, but just say, I'm working on, creating a family trust. And I understand that if I put our residents into the trust, that the mortgage needs to follow. Do you have any problems with that? And then they'll pass you to the right department where you would get the right answers and know the proper paperwork that would have to be filed, because you want to honor that the house has a mortgage and you're just trying to keep it intact while you're renaming the residence. And then in regards to putting the residents into the trust, that's a matter of working with the county that you're in, and it's usually a form that's called a quick claim deed. And if you tell them that you're working to put it into a family trust, they'll ask you for a trust certification, and that just says, it declares the name of the trust, who are the trustees, and that you have the power to do that. And some counties won't even, they'll just charge maybe a filing fee. Other counties may say, this might be a taxable situation, so I have to take a look at it. So it depends on your particular situation in regards to the county. But that's all you do. You just start asking people and talk about it as though you have a family trust. All across the country, people are very familiar with revocable living trusts, and what they just don't realize is revocable living trusts become irrevocable as soon as a person dies. So both revocable and irrevocable are words that should be familiar to the person in the department that handles trust relationships. So you just need to get to the right person, and don't be afraid to ask questions. I hope that helps.
Sounds good. The next question, Vespuccio asks, how can I be both the grantor and the beneficiary?
So in this particular case, as the grantor, when you sign the natural law trust, the private irrevocable contract, there is a page where, as the grantor, you're relinquishing all responsibility and all control over your assets. So it is very clear that you have an intention to let go of the ownership of these assets. And once you've done that, it is totally understandable that you might be one of many beneficiaries, or maybe you're a beneficiary and there's a humanitarian project and your assigned trustees, and normally you would have 2, or you'd have someone who's not related to you and a successor trustee. You could have a situation like that, and you would work out these details with Randall. But in that case, you can wear 2 hats. You can be the grantor, who then gives up control, and then you're one of the beneficiaries.
Yep. And it should be reminded that the client has the choice of being the trustee as well, but then they would need someone else to be the nominee grantor.
Yes.
Okay, the next question, Susan asks, can someone sue the trust to get the assets?
So unfortunately, the answer is yes. And there's a reason why we say yes, is because the trust is a legal entity. So it can sue and it can be sued. But what we do as trustees is we attempt to do our trust administration in such a way that we don't ever put ourselves in a situation where we would get sued for something. So here's an example. The grantor has put his assets into the trust, and 10 years later, someone sues the grantor, and somehow or another, they hear that he has a trust. So then they're going to name the trust. Well, guess what? That you get to respond to that and say, hey, I'm not part of that suit, because the trust assets are not owned by that grantor. So you could respond and say, well, I'm not part of that. You don't have any reason you don't have any reason to sue me because I'm not related to you in any way. So yes, the answer has to be yes, but then you have to look at exactly what situation you're asking, would you be sued about? And it may be in that particular situation that no, you couldn't be sued. So it depends upon what the details are. But it's way less likely to sue a trust for something than it is to sue a person.
Yes, I will add, Dominique, that I don't know of any natural law trust client who has ever had that happen.
Excellent.
And part of the reason is the privacy of the trust.
Yes. Yes.
It's not posted on public record. It's not attorney created. It's not state registered. It remains in the private files of the clients. And so its existence, first of all, is off the radar. So who's going to even know about it? And even the few people that may know that it exists may not have enough information about it to know who are all the officers and what are its assets in order to intelligently sue it.
Yes. And this, unfortunately, is one of the problems with revocable living trusts. They actually become certified when the person passes away. You file a document with the courts. And unfortunately, quite frequently, if you go look at court records, you can see people's living revocable trusts and you can see what their assets are. And this is how a lot of scams have happened.
Yep. So there is a lot of asset protection value in privacy.
Yes.
It looks like Oscar has another question. Oscar,
yes.
You had something more you wanted to say?
Yes, exactly about the one page of the grantor, the settler. Once they have been relinquished from their position, does the trust have to have a grantor remaining in the contract?
That's a really interesting question. So in a revocable living trust, the grantor remains there because he has the power to take back the assets. In a private irrevocable contract, the grantor doesn't remain because he's given up everything. He's given up all control. He's given up everything. So if the grantor creates a trust and then a year later passes away, that's not a problem. The trust continues to function perfectly.
Exactly. So basically the only purpose of the grantor in the BIC contract is to primarily set up the trust, period.
Exactly, which is why Randall sometimes, based on your situation, he may recommend a nominee grantor. So that's someone who is standing in and doing the initial blossoming of the trust, signing the trust indenture. Yes, we are now into existence. And then signing, I no longer have anything to do with this. I've birthed it and I'm walking away. That's correct.
Fascinating. Now it's starting to make more sense.
And if you look at SEC filings of various corporations, you will see most frequently, and all of your large corporations, they have nominees on the SEC filings. So it is very common for corporations to have nominees, officers. It's a very common thing to do in legal parlance, to have a nominee in order to afford greater privacy. So it is not an uncommon thing. It's actually very common. The public is just not aware of how much it's done.
Excellent. So then that transitions us to the trustee. So as a husband and wife relationship, we have the husband who's being the grantor, and then the wife is the trustee. But according to the BIC contract, it sounds like we can't have a direct relative because of the technicality of who owns the assets and so on and so forth. So I had put my distant cousin as the first trustee, and then if something happens to her, then would it be okay to fall into the wife position where the wife now is the second trustee and she can be the one to take over the trust? Or do both of them have to be present at the time of doing any business? I don't know if I'm explaining that correctly, but I
Yeah,
think
no, that's perfectly fine. So there's a lot of complexities in there. Number one, when you're working with husband and wife, it depends upon, we actually just did a class on this, so you'll have to jump in and look at the replay.
Oh, great. Yeah, which one is it? Which one is it?
We just talked about it last week.
Okay, I'll look it up. I'll look it up. Definitely.
Yeah, so what we talked about is there are, depending upon where you're located on the planet, and depending upon the country you're in and the city you're in, there are inheritance laws in regards to marriages and even common law marriages. And you have to sort of like look at and respect any rights of inheritance, in particular with married couples. So it depends upon, and you'll work this out with Randall, it depends upon what you're going to put into your trust as to how to go about it. But to simplify things, it may work out better for you to have a nominee grantor birth the trust, and then in the Brilliance and Commerce trust indenture, it gives the trustees the power to exchange additional assets into the trust. So that's why you or your wife, it's not necessary for you to be in the grantor position, because you both could be trustees. But Randall will always recommend, for a strong trust, you need an adverse trustee. And an adverse trustee in this particular situation, adverse means someone who's able to say no. In other words, that person didn't work for you, you don't work for them, and they're not blood to you, so they're not your sibling and they're not your parent, and they're not married to you. So yes, cousins work and in-laws work. So they're far enough away from you where they could say, no, I don't think that's a good idea.
Excellent. So what you're saying is that my second cousin, for example, instead of being a trustee, she can be the grantor of the trust.
Yes.
Excellent.
That would be perfectly fine. But
and then yeah.
You may want her to be, you could have 3 trustees. You may want, because there are times where I have signed as a nominee grantor for people. And then you would have your wife, yourself, and your cousin, would all 3 of you be trustees. Do you see, you're trying to create a strong foundation so that any of the activities of the trust, you can see that it clearly is a trust as a separate entity. It's not you as an alter ego.
Yes. Yes. Okay, but then what about beneficiaries? Now we have the 3 trustees. We have the husband and wife and the cousin, the 3 trustees, and now you have beneficiaries. Can the wife and the husband and the cousin be beneficiaries as well?
So this is where you'll talk it out with Randall.
Yes.
Yeah, I'll give you a suggestion. For me,
yes,
I started out as a beneficiary. I was the grantor and a beneficiary. And then I realized, wait a second, if I'm a trustee, I can receive payment as a trustee. Okay, that's fine. I don't need to be a beneficiary. So I don't, in my particular trust, I don't worry about being a beneficiary because I know I'm working for my trust and my trust can pay me a trustee fee. So think that through a little bit and send Randall an email and ask him some additional questions, and you'll figure out what makes good sense for you.
Well, this was extremely helpful because I already submitted my application with the information I was being asked of, but now this even brought me more clarity.
Excellent.
Yeah, so thank you again.
Love it.
This is fun.
Excellent.
Thank you, Tenson.
You're welcome. And the clarity will go on growing.
Yeah, thank you, Dominique. Appreciate it.
My pleasure. My pleasure.
Yes.
So, Dominique, we have a very common question from Doug. If I have a business in the trust, does the trust pay tax?
Good question. You are the driver of your ship. So this is a question that you get to answer. The way that I'm driving my ship, I'm making sure that I handle any tax issue before monies come into my trust. And then I know my beneficiaries can handle things however they feel they need to handle them afterwards. Because the whole taxing thing, it's a complicated question. It depends upon what city, what state you're in, what the business is that the trust is participating in. Are there statutory regulations that you're already enmeshed in, or have you unhinged yourself from some things? So I would say that particular question, give the details very specific to Randall and see if he's able to give some insight.
In general, though, the trust itself has no filing requirements by itself. So as
The
Dominic said
natural,
earlier,
right.
it can be seen as a pass-through.
And that's because the natural law trust is a contract. So
Right.
it is, it's not exempt, but it is an exception to their ruling because they are used to the statutory irrevocable contract that comes from a revocable contract, a revocable trust. So that's why those rules are written that way. They're used to statutory entities. They're not used to private contracts.
We've been doing this for decades, myself 3 decades, Randall 4, maybe 5, and we don't have any knowledge of anyone anywhere who's had a problem with that.
Excellent.
Thank you, everyone, for your beautiful comments. Let's see, someone says, oh, Eric, hi, Dominique, how to organize trust documents versus scanned documents with signatures and notarizations?
So you have to decide if
That's a
you
good
like
question,
to,
too.
yeah, if you like to print them all and put them in a binder with indexes, and then you can make a note in the front of your book of your pattern of how you file things. Or I do both. I have I'm actually using Proton Mail, and they have a drive similar to Google Drive. They have or Dropbox. They have a way to upload documents into the cloud as part of Proton. And so I have a electronic file that I keep, and I have a physical file. And in my electronic file, I file things the same way in folders, subfolders, as I do with my physical book.
And you have the choice of doing wet blue ink signature, scanning
Absolutely.
back into your computer to keep both electronic and paper copies,
Absolutely.
or using DocuSign, things like that.
Yes.
Paul asked, what about a restriction against the title of the home that is mortgaged to protect from creditors?
So that's, I believe you're talking about the homesteading. And that's a document that can be filed if I'm alluding to the correct thing that we're talking about. Homesteading is where it's either $25,000 or $30,000 of a home is protected from creditors. And I had a situation where 4 of my partners, it was very complicated. The end of our business ended up in a huge lawsuit, and we all homesteaded. And because we all homesteaded, we protected, because there are multiple owners of this property, we protected about $200,000 worth of equity in our home. So that was really important. So my understanding is when the trust takes over the ownership of that piece of property, that homesteading is no longer available because there is no individual to homestead it, and there is no reason to do that, because the trust could only be sued by creditors that the trust engaged with, which is it's different than us as a person. Sometimes, we'll have something happen and we'll use our credit card. If somebody has a heart attack, you pay a whole bunch of medical bills, and now you've got creditors pursuing you. That's very different from a trust. A trust is only going to get engaged in activities that make sense, and it's not going to indenture itself to a whole bunch of creditors. So my understanding is the homesteading would not be available once the piece of property is truly owned by the trust.
And if his question is relating to an ordinary house, he said if a restriction against the title of the home that is mortgaged to protect it from creditors, I believe he may be implying that he's wondering if it can be transferred to the trust with that restriction on it.
That may be. So in other words, if a piece of property is, the mortgage is held on a piece of property and you put the property into the trust, you would have to get permission from the mortgage company to do that. And they may ask the trust to sign on to the mortgage as one of the mortgagees. I don't have my name right, but yes.
Right.
Yeah, so the mortgage would follow the piece of property. You are correct.
Yeah. Okay, Doug asked, would the business need a trading as name, or can you just use an alias?
So there are different times that we file a DBA, doing business as, and it's usually called a fictitious name statement. And I had one situation where I owned communal property, and we wanted to have a communal checking account. And so I filed a fictitious name statement for an partnership other than, an association other than a partnership. So it was like we were all associated, but we weren't in business. We just wanted to be known by a name so we could put the name on the bank account. And then I used my social security number, and we were able to open the account with a fictitious name statement. So the only time that I would file a fictitious name statement is if a statutory entity is asking you for it. If they're not asking you for it, then you in your trust minutes can just write a trust minute saying, hey, this is the John Smith Trust, and we recognize that on some of our, internet business, we're going to be known as JS. So you can do that in your trust minutes and document that you're using an alias, but it really depends upon who you're interacting with, whether they are statutory and thus asking you to file a fictitious name statement. Hope that answers the question.
Yes. So those appear to be the questions for the moment. Thank you. That's fantastic. Any other general topics or themes or strings you want to tie together over today's series of ideas?
Yeah, I hope we get a chance to do this webinar again, because I want to know everything I've missed.
You mean you want to hear Randall's version of the slides?
I want to hear his wisdom.
We all do, but you've done a marvelous job, and I totally agree with the approach. And you also insert, from your experience, Dominique, you insert your background and knowledge, of corporations and LLCs and other types of trusts and accounting and, insurance. You have these various nice fields of expertise, which really help.
I did not understand when I became a stockbroker and insurance agent. I felt like a fish out of water, and I didn't understand why I did that. Now I know.
Yeah,
I needed the
yeah.
experience. I had to walk a mile in those moccasins.
It's like Robert Kiyosaki, you know, he had a lot of jobs and businesses, not so much to make the money, but to learn and to gain the expertise.
Yeah, yeah,
Mhm.
yeah. So I have made a lot of mistakes. The University of Life is very expensive.
That means you must have really enhanced your education. You've got a PhD in life experience, huh?
Yeah, but it's part of why I recognize that Randall has done such an amazing gift by creating this trust indenture. It is for driving a contract vehicle, it is very drivable, very comfortable, and I love it.
Is it driving a vehicle or sailing a ship?
Both.
Okay, everyone. Today was March 17th. Our next one is May 19th. Thank you very, very generously for joining us. A great group, wonderful questions, great comments, and it touches our hearts that there's so much appreciation and like-mindedness. So we will wrap it up here, and it's been about 2 hours. Know thy heart. Those that look outside dream, those that look inside awakening. Awaken from Carl Jung. And your life is a mirror, everything inside of you shown outside of you. Life is your reflection. So with those thoughts, thank you very kindly, and we will conclude for today.
Thank you, thank you, thank you.
Thank you, Dominique.